Vice President Sara Duterte is asking the Supreme Court not to overturn its July 25 decision that voided the impeachment complaint against her. Through her defense lawyers, Duterte warns that having the Supreme Court reverse itself will only allow whoever is in power to disregard constitutional restraints in the impeachment process and find a loophole to be used against political enemies. In a 27-page comment, Duterte's legal team says the High Tribunal's ruling requires no factual correction, contrary to the assertion of the House of Representatives. The Duterte defense team sought to attack the House's three main arguments. The first is that the Supreme Court misconstrued the chronology of events since the archiving of the first three impeachment complaints came before the filing of the fourth. Second, it erred in saying that the fourth complaint was transmitted to the Senate without a plenary vote. And third, that it wrongly ruled that the prior complaints were effectively dismissed due to Congress's adjournment. Duterte's team assails the motion for reconsideration for being based on what they describe as mere diversions obsessed with trivia and blind to the Supreme Court decision's genuine core reasoning. Duterte's team says the wafer-thin proximity between the archiving of the first three complaints and the filing of the fourth complaint on February 5 undermined the House's claim that the sequence of events had a meaningful bearing on the Supreme Court's ruling. They argue that the House exploited the definition of the word initiation in the Lambert cases of Francisco v. House and Gutierrez v. House to circumvent the one-year bar rule on filing impeachment complaints. The defense also believes the House motion for reconsideration should be dismissed because it lacked plenary approval from the chamber under the 20th Congress. They say it was never submitted for plenary deliberation and voting as shown in the official orders of business published on the House website between July 25 and August 4, when the motion was filed by the Office of the Solicitor General. They further question whether the Office of the Solicitor General acted unilaterally or at the behest of House Speaker Martin Romualdez, who had publicly commented on the filing. By bypassing the plenary, they believe the filing of the motion was not only procedurally defective, but also an unauthorized incursion upon the institutional prerogatives at the 20th Congress.